Mr. Kramer.
Good morning, Your Honor. Happy New Year, and may it please the Court. I represent a man who has, throughout, taken full responsibility for the delinquencies at issue, and therefore we take no exception to the findings of fact and conclusions of law drawn by Judge Stanfield in the Circuit Court. The facts are largely undisputed. We're dealing with a couple caught in a perfect storm of crisis. Tully Cross Farm, which they bought in 2004, wasn't Green Acres. In fact, considering the financial bloodbath they took, it may as well have been called Red Acres. Just after buying it, Mr. Yates' wife took ill. She could no longer work as a registered nurse, income they had counted on in launching this venture. The stock market crashed in 2008, which wiped out the market for purebred horses and their main revenue source. By 2011, they could no longer afford a staff to run an 83-acre farm, had to also lay off a bookkeeper who spent a couple of days a week just maintaining the books of this farm. And so my client, without any help, while tending to a disabled wife, also had to run an 83-acre farm on his own. In order to gain some revenue, to keep the farm afloat, save it from foreclosure so they could meet all their obligations, he returned to the practice of law. And so now he had two full-time jobs, not much sleep. They spent their life savings trying to save this farm. But what is very important here is that there has been no finding below of any intent to defraud, and there have been substantial mitigating factors. Though I've taken no exception to anything found below, I would argue that the sanction imposed in this case for conduct prejudicial to the administration of justice, which is certainly appropriate finding here, should not bankrupt or financially destroy this couple, particularly at a time when they're only coming out of one of the most devastating chapters of their lives. We are told, and this court has said it numerous times, that the purpose of attorney discipline is not to punish the attorney, but to protect the public. But even when our purpose is to punish, as in the case of punitive damages, for example, we tell our juries here in Maryland that their award should not bankrupt or destroy the defendant. Yet that is precisely what the petitioner would urge that this court do by indefinitely suspending him from the practice of law, thereby removing his sole source of revenue and truly devastating the couple, forcing them into default. In the past, when faced with situations like this, not even situations like this, situations which were involving far less hardship, the court has reprimanded an attorney who failed to file returns for years after discovering that his wife dropped the ball on that. That's the Gavin case. And some of those returns weren't filed for 6 years after that discovery. If a reprimand was sufficient for an attorney who always had the resources and the financial ability to rectify those problems, I ask, how can we justify harsher treatment of a lawyer facing far greater hardship? The petitioner, though, would impose a sanction identical to that which this court recently imposed in the Giannetti case to a lawyer who remained indifferent about making restitution, who failed to present any evidence of any mitigating factors, who obstructed the proceedings, and who was motivated by pecuniary gain through tax avoidance.
I have a question.
Yes.
You seem to be focusing on the 8.4b charge, which involves commission of a crime, and the hearing judge analyzed that allegation in terms of tax evasion, but did not really address what seems to be the more appropriate provision, which would be willful failure to file. And I didn't see you, so the hearing judge actually never discusses that in finding there's no 8.4b violation. I didn't really see a response in what you filed on that.
And that's an important question, Your Honor. What the hearing judge did find was that there was no criminal activity which, in the language of 8.4b, would involve dishonesty or untrustworthiness or would reflect adversely on his fitness to practice law. In general, that's the key.
Well, no, I think you're talking, dishonesty is 8.4c, I believe.
Well, that is true, except that 8.4b doesn't simply end the inquiry if there is technically a crime committed.
Right, but in analyzing whether 8.4b, whether there was a violation of 8.4b, the hearing judge never discussed the willful failure to file violation.
Well, I think that's because, as this court has long held, not every conviction of a failure to file is a crime involving moral turpitude, which would implicate 8.4b.
Although we've certainly found 8.4b violations for willful failure to file in the past.
You have when there has been an intent to defraud found.
Well, you don't need an intent to defraud for that violation.
Well, in a way you do, actually. And here's why. This court in Wallman, and this goes back to 1977, still good law, found that they asked the question, well, would failure to file necessarily implicate what was then the forerunner of 8.4b? And they found that no, it's not per se a crime in the old parlance, the old nomenclature, moral turpitude. And they defined moral turpitude in Wallman as accompanied by a fraudulent or dishonest intent, fraud and dishonesty. They found in that case that there was no evidence of fraud or dishonesty that would implicate the forerunner of 8.4b in that situation. So that merely a failure to file, even if willful in the more sterile definition.
Failure to file isn't necessarily a crime unless it's a willful failure to file.
True, but even if willful, the element of scienter, that of dishonesty or untrustworthiness, is not necessarily there because the way willfulness is more sterilely defined in the federal statute, for example, is that they took a lot of the scienter requirement out. And this court examined that and said, listen, because of that crime alone, failure to file alone, is not sufficient to implicate what is now 8.4b. It is not. What we need to have then is a finding of an intent to defraud or some type of deceit accompanying that failure to file. That failing to file, that is, knowing that you have an obligation to file, which we certainly did, and not filing, which would be considered willfulness in the more sterile parlance of that particular infraction, would not be enough for 8.4b. It would not. Here, we don't have any finding of an intent to defraud, and untrustworthiness, dishonesty, anything of that sort.
Did you cite Wallman
What's that?
Did you cite Wallman? Do you have the cite?
I did, in fact. It's 280 Maryland 453, and I'm particularly pointing to page 462 of that 1977 decision. And in fact, Judge Stansfield also discussed Wallman because, as we know from the comments to Rule 8.4, Comment 2, even though we no longer talk about moral turpitude, the comments say that that's still very much in play. And it is in play by virtue of the language of 8.4b, which says that it has to deal with dishonesty, untrustworthiness, or as Judge Bell told us, some type of character trait which would reflect an unfitness to practice law. And in this case, we do not have that here.
how do you reconcile the argument that you're making with the case of Gordon Tabak, AGC versus Tabak?
Right. Well, in Tabak, you had no mitigation at all. All right? Tabak, they actually did find that there was no reason for not filing. There weren't any extenuating circumstances found in Tabak. And in Tabak, this court still provided...
The argument that you're making that the 1977 case requires these specific findings with regard to intent, this requirement wasn't found by the court in Tabak.
Well, in a way, I would say that it, in some respects, did, because the problem in that instance was they didn't find any reason, no justification, and this court observed that, no justification whatsoever in Tabak for the failure to file.
But isn't that very different than finding this willful intent to deceive that you say is required?
Well, I would argue that it's not that different. If you have absolutely no reason not to file, you're not suffering any hardship, there aren't any extenuating circumstances whatsoever, and you know you have an obligation, but you just don't plain do it, that is what swayed the court in a case like Tabak.
Well, what about Clark? Clark was a failure to file case.
Right?
And there were circumstances in Clark where he was having difficulties and all of that, and it was still an 8.4b violation.
Well, in Clark, first of all, very recently, this past summer, Judge Booth, writing for unanimous court in Eugene Kane's case, observed that ordinarily 8.4b violations deal with situations in which there have been criminal charges and convictions. In that instance, this court actually overruled or sustained exceptions to findings against the attorney on 8.4b, dealing with the deduction of personal and family cell phone bills as business expenses.
I'm talking about Clark, which was a failure to file that I wrote many years ago. I believe it was in 2002 or 2003.
It was actually a 2001 case.
Okay, 2001. Well, I'm taking it even further.
And Your Honor also
right.
Provided, as this court did.
That had nothing to do with cell phone records. I gather Kane did. But that wasn't an overrule of Clark. It was just a recognition of different circumstances in Kane, because I also sat on Kane. I mean, it didn't overrule the sanction in Clark or the violation in Clark.
Well, but what did the court do? The court provided a suspension with an immediate right to reapply, because it found that the lapses...
No, but we're talking about violations. We're not talking about the sanctions.
Right.
Because the sanctions run the gamut because of the mitigation. But I thought we were talking about what is a violation of 8.4b. And under Clark, this would be a violation of 8.4b in terms of the violation without even considering the sanction. Because those are separate issues.
Well, then I don't know that this court is going to overrule Gavin, a later decision in which the attorney didn't have a basis for failing to file, but there wasn't an 8.4 B violation there.
It may not have been charged.
But also the distinction between here and Clark is that in Clark below, the court found an 8.4 B violation. In this case, the court did not. The fact is that in this case, we don't have a finding of anything more than, for various circumstances, he was unable to file his returns for a period of several years.
So there's no 8.4, I'm sorry, go ahead. So there was no 8.4 violation found at all under your analysis? I mean, obviously it's a conclusion of law, and if we do whatever we
it is a conclusion of law, but I think one has to recognize, what is the gravity, even if there is arguably an 8.4b violation. Is that the end of the inquiry? Of course not. I mean, you have to put it in context. If what we're considering is, and my sole interest in this case, is to save this couple from further financial devastation. And in that respect, you have to look at, were they simply indifferent to the need to file taxes? No, that's not the facts here at all.
I just want to make sure we're all clear. Does Mr. Yates acknowledge that he willfully failed to file for 7 years? Does he acknowledge willfulness?
Well, I guess willful is more of a legal term, but he certainly didn't file for that period, yes.
Well, I don't know if you answered my question. Does he? I would like to know, I understand your argument about the sanction. I think I understand that you're not conceding that 8.4b is decided just with if he concedes willfulness, but what's his position as to whether, I thought there was some testimony about acknowledging the legal duty, the knowledge of the legal duty.
He certainly acknowledged the knowledge of the legal duty.
So it sounds to me like you're conceding that he's conceding that he willfully failed to file. But can we get that off the table?
Yes. But even if willful, under this court's reasoning in Wallman, and later in Post, which was a 1996 decision, 350 Maryland 85, you need more than that. You need some scienter here as well to implicate 8.4b. That one I'm not conceding, because I don't believe that this really qualifies as an 8.4b violation in that respect.
Was this argued before the hearing, Judge? My original question, I was just curious that he never even addressed it.
Well, that perhaps is because Bar Counsel made the comment that this individual was trying to essentially cheat on his taxes. That he was trying to, I think in Mr. Blow's words in closing, trying to keep all the money for himself, which I was like, well, what money? So I think that there was a definite slant to the state's case that this involved something more than just, well, he knew it and he just didn't do it. It was an argument that he really did evade his taxes. And so I think that's where a lot of the focus at trial was placed by the way the petitioner went about presenting the matter. Thank you.
All right, thank you, Mr. Kramer. Mr. Blow.
Good morning. May it please the Court. Michael Blow on behalf of the petitioner. Well, it's true that Mr. Yates suffered a period of personal and financial hardships. The underlying facts of this case are undisputed. For 7 consecutive years, Mr. Yates failed to timely file income tax returns and failed to timely pay taxes owed to both the federal government and the state of Maryland.
Let me stop you there just to make sure that I recall correctly. The failure to file timely doesn't mean that he wasn't. Did he submit during that period any late filings of earlier years?
No, Your Honor.
Okay.
From the period of 2011 through 2017, did not file at all.
Okay.
It wasn't until the summer of 2018 where he filed tax returns 2011 through 2017.
All right, thanks.
By not filing his taxes, Mr. Yates showed a blatant disregard for the most basic requirement of all citizens. I would like to address the Gavin case that was cited by Mr. Yates' counsel. The Gavin case is easily distinguishable from the facts of the case at bar. In the Gavin case, the attorney in the Gavin case, his wife was responsible for filing the joint tax returns for the couple. There was a period of time for, I believe, approximately 3 years where the attorney's wife was not filing tax returns, but the attorney had no knowledge of that.
Well, but if they were filing joint returns, I don't know. I always sign off with my husband and I filed jointly. We both signed. What was Mr. Gavin's situation for those 3 years? He just didn't, well, you tell me.
For 3
Based on
years.
the record, of course, in the opinion.
Well, essentially for those amount of time, I believe it was 3 years, the wife effectively deceived Mr. Gavin into believing that the tax returns were being filed, but this court found that he had no knowledge. He genuinely believed during that time period that these tax returns were being filed. It wasn't until after the fact that he learned that the tax returns were not being filed. That is very different from this case, where Mr. Yates was responsible for filing the couple's joint tax returns, and he testified at the hearing that he was absolutely aware every single year that he was obligated to file those tax returns and that he was not, federal or state.
What is your response to counsel's argument, Mr. Kramer's argument, that in the discussion with the court about what do we mean willfulness to be?
Yes, Your Honor. This court has consistently held that in cases such as Atkinson, Tabak, Giannetti, Katz, that a knowing and voluntary violation of a known legal duty is sufficient to constitute willful within the meaning of the criminal statutes. And this court has been also very clear that evidence of a deceitful or fraudulent motive is not required. Mr. Yates' position is completely contrary to this court's jurisprudence. At the hearing, Mr. Yates testified that he was aware at all times of his obligation to file federal and state income tax returns, and he knew that his failure to file returns constituted a criminal offense. As Judge McDonald pointed out, the hearing judge improperly limited his analysis of the criminality of the respondent's conduct only to U.S. Code Section 7201, which is tax evasion. The hearing court failed to consider Section 7203 and the Maryland Tax General Article 131001. The distinction between those statutes is critical because Section 203 in the Maryland Tax General Article only require a willful failure to file income tax returns. 7201 requires an intent to evade the obligation to file tax returns. It requires that there be some evidence of an actual intent, whereas 7203 and the Maryland Tax General Article do not require any intent found. And while it may be true that Mr. Yates may not have violated Section 7201, it's clear that he did violate Section 7203 in the Maryland Tax General Article. It has also been well established by this court that failure to file income tax returns adversely reflects on an attorney's fitness to practice law. That is well established. There is no ambiguity on that point. The evidence in this record sufficiently establishes that Mr. Yates' conduct was in fact a violation of Rule 8.4b. The petitioner also took exception to the hearing judge's failure to find that Mr. Yates violated Rule 8.4c. It has also been well established by this court that an attorney's repeated failures to file income tax returns is a dishonest act. In Atkinson, this court held that an attorney's repeated failure to file tax returns for an uninterrupted period of 11 years was in fact dishonest. Likewise, in the Giannetti case, this court held that a respondent's failure to repeatedly file tax returns for an uninterrupted period of 7 years also constituted conduct involving dishonesty. In this case...
Excuse me, Mr. Blow. When did Mr. Yates ramp up, or however one wants to put it, engage in sort of the stand-in counsel niche? It was described by Mr. Kramer, I believe, as niche practice. When, in the course of that period of time when he wasn't filing taxes, was he doing that? Was he engaging in the practice of law?
Your Honor, I believe the testimony was that it was around approximately 2011 where he resumed the practice of law and began acting as a stand-in attorney again.
Mm-hmm. And the years in which he did not file?
That was 2011 through 2017, Your Honor. This case, like Atkinson and Giannetti, Mr. Yates has failed to file federal and state income taxes for a substantial duration of time from 2011 through 2017.
There were aggravating factors in Giannetti. Why is this case not more similar to Tabak, where the sanction was a suspension with the right to reapply in 60 days?
Well, Your Honor, I believe that the distinction is that in Tabak, the period of delinquency was also 7 years, but it wasn't 7 consecutive years. In Tabak, I believe it was initially there was 3 years where he failed to comply, and then there was a period where the attorney in Tabak was able to make some payments and come into compliance. But then there was a separate period, I believe from 90 to 93, where he again failed to adhere to his tax obligations. So that's one difference. The other difference is, I don't believe Tabak had any prior discipline. Mr. Yates does have a prior reprimand from this court from 2006 for a violation of Rule 1.3 and 8.4D. So that is one significant difference, Your Honor. And also, I believe that in Tabak, there wasn't, again, as I say, I don't believe he had any prior discipline. Mr. Yates definitely does have prior discipline, Your Honor.
Would it be appropriate or possible to look at this case as somewhere between Tabak and Giannetti in terms of the right to reapply in 60 days and 1 year?
Certainly, Your Honor. The facts, the underlying misconduct is similar to Giannetti and is similar to Tabak and also Atkinson. So this court has been very clear that in cases involving an attorney's willful failure to file income tax returns, that an indefinite suspension is appropriate. In terms of the time period before that attorney has a right to reapply, that does vary depending on the facts and the different aggravating and mitigating factors, Your Honor. The petitioner's position here in this case is that Mr. Yates' conduct is, the facts fall more similar to Giannetti than Tabak, but it's certainly within that range, Your Honor.
Well, in Giannetti, there wasn't any disclosure by Giannetti. Isn't that correct? I mean, in the sense that, wasn't there a circumstance here where there was a self-disclosure of the failure to file? I don't really understand all the circumstances as to how that happened. And I gather it wasn't a disclosure to the IRS, but there was a disclosure here, was there not? And a cooperation. In Giannetti, as I understand, there was not.
So in a sense, Your Honor, in the Giannetti case, the way that Bar Counsel found out about his failure to file tax returns was that he was testifying in a family law matter. And then that's where the issue...
He was getting a divorce.
Right. And that's where the issue first came to light. And that's similar to this case, Your Honor, where here Mr. Yates was participating in a deposition. He was giving a deposition. And in that deposition, he was asked about his failures to file these tax returns. And then he did answer honestly. But in a deposition, he's under oath. He's already required to answer the questions honestly. It's not a situation where Mr. Yates just on his own wrote Bar Counsel a letter and informed Bar Counsel of his failure to file taxes. It came out in the process of a deposition where he was obligated to tell the truth in the first place. So in that sense, yes.
And then he started paying the back taxes?
So the timing was, the deposition was in June of 2017. Mm-hmm. In October of 2017, Bar Counsel sent him formal notice that investigation was commencing regarding his tax issues. And then it wasn't until August of 2018 where he finally got around to filing his past due tax returns. And then it wasn't again until 2019 where he finally started making substantial payments towards his tax obligations, Your Honor.
But during that time, the service, neither the service nor the controller actually investigated or charged him?
Not to the petitioner's knowledge, Your Honor.
Thank you.
The petitioner also accepts to the hearing judge's finding that the respondent's disability constituted mitigation. The petitioner does not challenge the fact that Mr. Yates does in fact suffer from various disabilities. However, Mr. Yates has failed to prove that there is a sufficient connection between his disability and his failure to attend to his tax obligations for a period of 7 years. The hearing judge relied on the testimony of Dr. Stanley Sack, who testified that Mr. Yates' disabilities, in combination with the various contemporaneous life events that were happening with Mr. Yates during that time period, caused Mr. Yates to feel overwhelmed, impaired his ability to focus, and diminished his capacity for action. But it is important to note that Dr. Sack did not testify as to the degree that Mr. Yates' disability impaired his ability to file income tax returns. And Dr. Sack did not offer any opinion, and also the court did not find that Mr. Yates' disabilities were the root cause or a substantial cause of his failure to attend to his tax obligation.
Did the doctor render any opinion as to whether these alleged disabilities prevented Mr. Yates from practicing law?
So he did testify to that point. Dr. Sack's testimony was that Mr. Yates' disability is not of a completely debilitating nature, and that he was, according to Dr. Sack, he was still able to practice law, and also at the same time he was this disability to some degree impaired his ability to file taxes. That was the testimony from Dr. Sack. It does not seem consistent. During the hearing, Mr. Yates' own witnesses testified that Mr. Yates runs a successful law practice, and he runs it by himself with no help from any other support staff. He's responsible for billing attorneys, and he's responsible for every aspect of that law practice. And these other attorneys who worked with him testified that there were no issues, and this is during the same period. There are no issues. Apparently, Mr. Yates is able to accurately bill his clients and bill them on time. But for some reason, his disability only affects his ability to attend to his tax obligations.
Isn't this during the time period, though, that Mr. Yates is acting as a stand-in counsel, so that the nature of his representation is maybe different than a solo with an ongoing caseload in client matters?
Correct, Your Honor, correct. He was acting at that point as a stand-in counsel. However, all the attorneys testified that Mr. Yates was always well prepared and was always on time. And it really wasn't consistent with someone suffering from a severely debilitating disability, the type that would serve as mitigation for his failures to file income tax returns. As I've stated earlier, the petitioner's position is that this case is most similar to Giannetti, and we would ask the court to sustain the petitioner's exceptions to 8.4b and c, and to recommend a sanction of indefinite suspension with a right to reapply for reinstatement no sooner than 1 year, unless the court has any additional questions.
Thank you, Mr. Lowe.
Thank you.
Mr. Kramer.
Thank you, Your Honor. I'd like to remind the court of its holding in the Wallman case by taking a look. I know it's in the Atlantic Reporter at page 462, but I don't have the Maryland site. The court thought that the better view in terms of 8.4b, what became 8.4b, is represented by the cases holding that not every conviction of failure to file is a crime involving moral turpitude, but that the issue depends on the particular facts of the individual case. As we have stressed, the federal cases have eliminated fraud and dishonesty, the very conduct which we identify moral turpitude as elements of the crime of failure to file. Consequently, such a conviction does not on its face establish moral turpitude. In the final analysis, then, whether failure to file is a crime involving moral turpitude hinges on the facts present in the individual case at hand. And in this particular case, they found that there was no evidence to show that the failure to file returns was accompanied by a fraudulent or dishonest intent, which, Judge Baran, is why I've answered your question accordingly, which is that even if willful by the definition of the criminal statute, it still wouldn't be a crime that would merit a violation of 8.4b.
But if that's the case, regarding 804C, how do you deal with what the court said in Atkinson, that the repeated failure to file tax returns, particularly when it spans an uninterrupted period of over 10 years, is not a minor criminal offense, it is a dishonest act?
Well, because they actually did find below that there was dishonesty. And I believe in Atkinson, I think there was indeed a charge to that effect. This court, in Eugene Kane's case, very recently found it very important to observe that the respondent had not been charged with or convicted of any crime. I should also add that in the Tabak case, there was a guilty plea involved there. So, and we had no mitigating factors there. I don't see, for the life of me, how this is in any way even as egregious as Gavin. Because Gavin had no reason to not file. He had all the resources in the world. He even had records as to what his income was. Here we had neither. And let me point out that although Mr. Blow would deprive us of the benefit of the restitution or efforts to remediate this problem by saying, well, we only really did it after this came out, we volunteered that at deposition. This wasn't teased out of us as if we were the subject of the deposition as in a Giannetti case. We voluntarily said, listen, we failed to file our returns and pay our taxes for a period of years. It was the honesty that got us investigated. It was voluntary. This was not a Giannetti situation. In Giannetti, even up to the time of oral argument, this court observed that there hadn't been any effort made whatsoever to discharge the tax obligation. In this case, they had to fire sale this farm for land price, unimproved land price. They sold it at a major loss. Had they waited even a couple more years, they might have been able to discharge all of their obligations. They were able to discharge all of the federal, and most of the states save about $13,000 to $15,000, and they're on payment plans, which they're current on. If this court were to say, we're suspending you indefinitely, and you have a right to reapply, we'll say, let's put it between Tabak and Giannetti, and we'll give you a right to reapply in 6 months, I can tell you in 6 months, they won't have a pot. They'll be in default because they won't have any business income whatsoever. And it takes a long time to ramp up a practice, even a niche practice like this one. Yes, it started in 2011, but they didn't have any income until at least 2015 from that. Meanwhile, they're depleting their 401ks. They're doing everything they can to survive.
Then, Mr. Kramer, according to what you're saying, any period of suspension would be a death knell.
Well, maybe a 30-day definite suspension would not be. That is, okay, you're taking your lumps, you're not making any money for 30 days. Can they weather that storm? Perhaps. They could. But if you say indefinite, we have no guarantee that even if we have a right to immediately reapply, that we're going to be immediately reinstated. I mean, then you have all of these things you have to submit to Bar Council. It's quite a bit.
So it's the difference between a definite suspension and an indefinite suspension.
And the duration, of course.
And the duration.
Because if you're out for 6 months definite, well, you know you're coming back, but what are you coming back to? Nothing. No money. You've lost all of your contacts. They've had to go and find other people to cover for themselves, these attorneys. And so, by necessity, maybe they can, out of loyalty, hold off for a month. But this is the problem. We're debating all these technicalities of 8.4B and C and this and that and the other. I'm talking about what really happened here. We're dealing with a couple in crisis. Life happens, and it happens to lawyers too. And in this particular case, they did everything they possibly could to get themselves out of this mess. They even tried a long time ago, back in 2014, to sell the farm. They put it on the market for 6 months. Nobody even called. This is not a situation where, they didn't even care about rectifying the problem until after this all came to light. No, years before this came to light. And years before, they had a payment plan, monthly payments to the state of Maryland. In 2015, which was the first year their accountant said they had any income whatsoever from the business, they more than double paid. They overpaid their taxes by double. They owed about $3,600. They paid $7,500. They didn't have any idea what they owed, and they could never even get that back, by the way, because of limitations. But the bottom line is you're dealing with individuals who tried their best. They were not cavalier about this. They were not indifferent to their obligations. And yes, it was a daily struggle. But, are the sheep going to get fed? How am I going to put these records together? At the end of the day, they had to declare this whole thing a hobby. If they had the records, they probably wouldn't have had any liability at all. But they can't prove that because they didn't have the records anymore. The accountant testified to that. In fact, the accountant said they probably have grounds for an abatement, which is what they're pursuing. Why would you have grounds for an abatement? Because you really didn't do anything willfully wrong. I understand the definition, Your Honor, but we have to look at what they really did. And what they did was a lot to try to get out from under. This case involves far more hardship than Gavin, where you imposed a reprimand. I don't understand for the life of me why that wouldn't be appropriate here.
Mr. Kramer, the 2006 reprimand, do you know whether it was a commission reprimand or reprimand issued by this court?
The 2006 reprimand, I believe it was commissioned, and let me make a point on that reprimand. Reprimands work. In this case, he was reprimanded because he dropped the ball on a deadline. And he said to himself, you know what, I got to get out into something else because I don't want anybody else to be harmed here. And that's why he went into farming. He thought that there might actually be greener pastures in some ways, to pardon the pun. But he did that. When he finally got back, he understood his limitations, and he designed a practice to work within them. Reprimands do work. Reprimands aren't hollow sanctions. He took that reprimand to heart, and he never let any clients down despite everything they were going through. That, frankly, although I know an aggravating factor, but let's look at what really happened. Let's not just look at what the lists are on the statutes and mitigating and how add them up and all that. That's not what this court's about. It's about looking at what really happened here. He learned from that, and he didn't repeat that mistake. Judge Stansfield presumed that the reason that prior discipline is an aggravating factor is that, well, if somebody hasn't learned their lesson, well, we'll nail you now. But he did learn his lesson. And not only that, he's learned his lesson this time as well. He now, without the financial drain of the farm, was able to hire that CPA back, bookkeepers, to monitor and maintain his records. He could have gotten an extension on his 2018 returns, but he said, and this is pivotal, somehow for me later never comes. Here's a man who's learned. Why destroy him? That's not what this is about. This isn't about punishment. This is about protection. It's about the fact that this is not likely to ever be repeated again. Now, there's been no contention, no rebuttal to Dr. Sachs' testimony of the ADHD. They're applying a Vanderlyn standard? Vanderlyn has nothing to do with this case. This is not a situation of disbarment, of intentional dishonesty and fraud and theft of funds and intentional misappropriation, where a Vanderlyn standard says we're only going to consider it to be mitigating if you absolutely were totally debilitated. That's not the standard in determining whether the ADHD would qualify as a mitigating factor. Of course it qualifies as a mitigating factor. There's been no testimony that he was incapable of physically filing a tax return. But when you've got all of this perfect storm of crisis weighing on you, and then you have ADHD besides, you're paralyzed. And what it took, as Dr. Sack testified, was another crisis to galvanize into action. That's life. That's reality. That's consistent with what we all know to be the case. But it's not a scenario where he was just ignoring all of these things. They tried to get out from under, and they found it impossible to do so. But they were trying to save the farm, and for good reason, not only for their own financial well-being, but to be able to meet their obligations. If they let this thing go to foreclosure, everybody loses. So that is called prudence. That's not called indifference. This is not something that is likely to be repeated. And I would urge this court to really consider the practical impact of any sanction imposed, that I do believe a reprimand would be appropriate here. If it was good enough for Mr. Gavin, who serves with me on the MSBA Ethics Committee, and it didn't seem to do the public any harm, I think it's also good enough for Mr. Yates, who went through far more hardship, who didn't simply let this go. He did his best to survive. And all I'm asking is that you allow him to survive this.